11:47 a.m. Beverly Crest, Los Angeles. October 14th. The motorcade moves without sirens. 12 black Suburbans roll up Tower Grove Drive in a tight column, headlights doused, tires whispering against wet asphalt. At the wrought iron gate of a 14,000-square-foot Mediterranean estate, the lead vehicle stops. An agent steps out. He punches a 6-digit override into the security panel, a code obtained hours earlier from a cooperating witness in federal custody. The gate swings open. What the FBI's Los Angeles field office expected to find that morning was a financial crime scene, a white-collar takedown, wire fraud, tax evasion. Maybe structured currency violations tied to a shell company network they'd been tracking for 19 months. What they found instead would, within 72 hours, become the largest coordinated trafficking investigation in the Bureau's modern history. This is the story of how a routine asset seizure cracked open a $2.5 billion criminal enterprise operating beneath the surface of American entertainment, finance, and politics, and how a single locked door in a wine cellar changed everything. The target of the October 14th raid was a man whose name appeared on charity gala programs across 2 coastlines. A producer. A philanthropist. A board member of 3 nonprofits ostensibly dedicated to youth welfare. For the purposes of this report, and because superseding indictments remain under partial seal, we will refer to him by the designation used in court filings, Subject 1. Subject 1 had built a public persona over 15 years. Profiles in glossy magazines. Keynote speeches at industry summits, a foundation that on paper distributed $4 million annually to programs serving at-risk youth in Los Angeles, Miami, and New York. On paper, the reality, federal prosecutors would later allege in a 312-page indictment, was that the foundation served as a logistics and laundering apparatus for a transnational network moving victims across at least 4 U.S. states and 3 foreign jurisdictions. The charitable disbursements were real. They had to be. They were the cover. Special Agent in Charge Maria Restrepo led the entry team that morning. According to the operational after-action summary, agents secured the ground floor in under 4 minutes. Subject 1 was located in the master suite. He did not resist. He requested his attorney. He was placed in restraints and escorted to a waiting vehicle. The search warrant authorized seizure of financial records, electronic devices, and any documentation related to 17 specific shell entities. Standard procedure. Agents fanned out through the residence with evidence bags, cameras, and forensic kits. It was 4:31 and when Agent Daniel Cho descended the staircase into the wine cellar. The cellar itself was unremarkable. Climate-controlled, roughly 800 bottles, a tasting table of reclaimed oak. But the west wall, Cho noted in his contemporaneous report, sounded hollow when tapped. The mortar lines between 2 sections of stonework did not match the rest of the room. A structural engineer was called from the staging area outside. By 5:15 a.m., a section of the wall had been removed. Behind it, a steel door. Biometric lock. No exterior handle. This is where the investigation pivots. This is where the financial case becomes something else entirely. Federal agents do not, as a rule, breach unknown structures without tactical support and a warrant amendment. By 6:40 a.m., both had arrived. The amended warrant, signed by a federal magistrate via secure video conference, authorized entry into any concealed space within the premises reasonably believed to contain evidence of the enumerated offenses. The door was breached at 7:12 a.m. What lay beyond it was not, as initial sensational reporting would later claim, a dungeon. It was something more clinical, and in many ways more disturbing. A 2,200-square-foot subterranean facility, professionally constructed, with independent ventilation, plumbing, and electrical systems isolated from the main residence. 6 small bedrooms. A medical examination room. A commercial-grade kitchen. A server room. And in the server room, 48 terabytes of encrypted data. The individuals discovered in the facility, 7 in total, ranging in age from 19 to 31, were removed by Federal Victim Services personnel within 90 minutes of breach. Their identities remain protected. Their accounts, given over the following weeks to specially trained interviewers, would form the evidentiary backbone of every charge that followed. We will not detail those accounts here. They belong to the survivors. But we will detail what the servers contained. It took the FBI's Cyber Division 11 days to break the primary encryption layer. Inside, forensic analysts found what one supervisor described in an internal memo as a corporate intranet for criminal enterprise. Financial ledgers spanning 9 years. Client lists with 1,143 unique entries, each assigned a numeric identifier and a risk classification. Shipping manifests disguised as talent management contracts. Travel itineraries cross-referenced to private aviation records. Communications logs from an encrypted messaging platform built on a forked version of an open-source protocol. A platform, agents determined, that had been operating undetected since 2019. The total volume of money moved through the network, as reconstructed by forensic accountants from the Treasury Department's Financial Crimes Enforcement Network, exceeded $2.5 billion across the period covered by recoverable records. $2.5 billion. Routed through 43 shell entities in 11 jurisdictions. Cleaned through art purchases, real estate flips, cryptocurrency mixers, and, most audaciously, through the same charitable foundations that had earned Subject 1 his philanthropic reputation. The donations were not the laundry. The donations were the receipts. Every legitimate disbursement created paper that obscured the illegitimate flows beneath it. How does a network this large operate without detection? The answer, the indictment alleges, is that it didn't operate without detection. It operated with protection. On October 17th, 3 days after the initial raid, the U.S. Attorney's Office for the Central District of California unsealed a coordinated set of arrest warrants. By the morning of October 18th, federal agents had executed simultaneous operations in 12 cities. The arrests included a senior partner at a Los Angeles entertainment law firm charged with conspiracy and obstruction, a former state-level elected official from a southwestern state charged with bribery and accessory after the fact, 2 private banking executives based in Miami and New York charged with money laundering and structuring, a licensed psychiatrist who had served as the network's medical contractor charged with multiple counts of conspiracy and falsification of records, 3 individuals operating private aviation services charged with conspiracy and trafficking-related offenses, a registered lobbyist whose firm had been retained by one of Subject 1's foundations charged with conspiracy and false statements to federal investigators, 23 defendants in total in the initial wave. 11 more would follow in the superseding indictment filed in December. At the press conference on October 18th, the acting Deputy Attorney General stood before a podium and read from a prepared statement. The footage is publicly available. The relevant passage, the defendants charged today did not operate at the margins of American life. They operated at its center. They sat on boards. They attended galas. They wrote checks to political campaigns. They were trusted, and they used that trust as both shield and weapon. The Department of Justice will not rest until every individual who participated in, profited from, or knowingly enabled this enterprise is held accountable under the law. The statement lasted 4 minutes. No questions were taken. How did this go on for 9 years? The forensic timeline assembled by federal investigators offers a partial answer, and it is not a comforting one. The network appears to have originated in 2016 as a relatively small operation, what one analyst's report describes as a closed-circle arrangement among approximately 15 principals. It expanded in 2018 after a corporate restructuring that introduced 2 new financial intermediaries. It grew again in 2020, when pandemic-era disruptions to legitimate entertainment industry operations created cover for unusual travel patterns and cash movements. By 2022, internal communications recovered from the seized servers reference client capacity constraints, the language of a business scaling beyond its operational capability. 3 separate federal complaints had been filed against Subject 1, or affiliated entities between 2019 and 2023. All 3 were closed without charges. The reasons cited in case closure memoranda, now subject to internal Department of Justice review, ranged from insufficient evidence to resource reallocation. At least one of those memoranda, according to reporting by the Los Angeles Times, was authored by a prosecutor who later accepted private sector employment with a firm that had represented one of the network's shell entities. The Office of the Inspector General has opened an internal review. Its findings are not expected before next year. But the pattern is clear enough to name. This was not a network that hid in shadows. It hid in spotlights. It hid behind reputation, behind philanthropy, behind the assumption, still embedded in too many institutions, that wealth and access correlate with virtue. They do not. Consider what $2.5 billion buys. It buys silence, in the form of non-disclosure agreements with 7-figure penalty clauses. The legal files recovered from Subject 1's residence contained 89 such agreements, signed by former employees, former associates, and, in at least 14 cases, identified victims. It buys distance, in the form of layered corporate structures that place the principal 3 or 4 legal entities removed from any specific transaction. The forensic accounting team has cataloged what they call the cascade, a sequence of transfers through which a single payment could be routed across 6 jurisdictions in under 48 hours, arriving at its destination effectively untraceable to its origin. It buys influence in the form of campaign contributions, charitable board appointments, gala sponsorships, and the slow accumulation of social capital that makes uncomfortable questions feel impolite. It buys, most critically, time. 9 years of it. And during those 9 years, according to the case file, the network is alleged to have trafficked, exploited, or otherwise victimized at least 178 identified individuals, with investigators believing the true number to be substantially higher, 178 names. Each one a person, each one missed by every system designed to catch precisely this. Subject 1 was arraigned on October 22nd. He pleaded not guilty to all 47 counts in the initial indictment. His bail was denied. His attorneys filed motions to suppress the evidence obtained from the concealed facility, arguing that the warrant amendment was procedurally defective. Those motions were denied on November 8th. Appeals are pending. The trial is currently scheduled to begin in the spring of next year. It is expected to last between 4 and 6 months. The government's witness list, partially unsealed, includes 312 names. The defense witness list, also partially unsealed, includes 17. Of the 23 defendants charged in the October 18th wave, 9 have entered cooperation agreements. Their testimony, prosecutors indicate, will form the connective tissue between the network's financial architecture and its operational reality. Several of those cooperators have provided information leading to ongoing investigations in 3 additional federal districts. There will be more arrests. The acting Deputy Attorney General has said so publicly. The question is not whether the next wave is coming. The question is how high it reaches. A word here about what this story is and what it is not. It is not a story about a single bad actor. The framing of Lone Monster is comforting precisely because it suggests that monsters are rare, identifiable, and once removed, the danger passes. The evidence in this case suggests something quite different. It suggests an ecosystem, a set of professional services, institutional blind spots, and reputational laundering mechanisms that made an enterprise of this scale not just possible, but, in retrospect, almost predictable. It is not, either, a story that ends with these arrests. The 1,143 client identifiers recovered from the servers represent 1,143 separate investigative leads. The encrypted communications platform, now in federal possession, may yield evidence relevant to networks operating well beyond the one centered on Subject 1. The financial cascade infrastructure, once mapped, can be used to identify similar structures elsewhere, and it is not, most importantly, a story whose moral weight rests with the prosecutors, the agents, or the journalists who cover their work. It rests with the survivors. 7 of whom walked out of a concrete room beneath a Beverly Crest mansion on the morning of October 14th. 171 more whose identities have been documented in the case file, an unknown number beyond that, whose stories have not yet been told and may never be. You have probably noticed, in the course of reading this account, the absence of certain details. The full name of Subject 1, the names of the celebrities, executives, and officials who appeared on the client lists. The specifics of the survivor testimony. This is deliberate. Some of these details remain under seal because the legal process requires it. Others are omitted because their publication would compromise ongoing investigations or further harm individuals who have already been harmed enough. Still, others are absent because, frankly, the spectacle of naming would distract from the more important story, that the systems we trust to detect and prevent this kind of harm failed for nearly a decade, and that the reasons for that failure are structural, not incidental. Reform is being discussed. Legislation has been proposed in 2 committees that would tighten reporting requirements for charitable foundations above a certain asset threshold and expand the authority of FinCEN to flag transactions involving private aviation and luxury real estate. Whether either measure becomes law is, at the time of this writing, an open question. What is not open is the obligation it places on the rest of us. If you work in finance, in entertainment, in law, in philanthropy, in journalism, in government, the cascade ran through institutions you may know. The shell entities were filed in registries you may have access to. The donations were processed by foundations you may have reviewed. None of that makes you complicit. All of it makes you positioned. Pay attention to the things that don't add up. Ask the uncomfortable questions when the easy answer is to look past them. Trust the patterns, not the polish. The gate on Tower Grove Drive opened at 3:47 on October 14th because someone, somewhere in the chain, finally said something. One witness. One cooperating account. One piece of testimony that turned a financial probe into a rescue operation. That is how these things end. Eventually. When they end at all,